Hi guys, so chapter 10 looks at pretrial procedures, and so we'll start off with the arrest because that's where the criminal process really kicks off. A complaint is filed either before or after the arrest, and it depends on how the suspect was arrested. We'll remember that an arrest needs to have probable cause for it to be constitutionally acceptable. For warrants, officers swear an affidavit, and they need to swear to probable cause. Again, typo there. After an arrest occurs, the suspect is formally booked at the police station. As part of this booking, formal paperwork is taken, fingerprints are taken, photographs are taken, and some jurisdictions take DNA swabs at this point too. And frequently there's a quick release, especially for someone who's a first-time offender or who didn't commit a violent offense. But other times defendants have to stay until later on in the process. After the arrest and the booking, the charging decision occurs. So the charging decision is made by the prosecutor. This is really critical, probably the most critical decision in the point of the process. Some people refer to this as the gateway to justice. Prosecutors are free to dismiss the case. They don't have to move forward. And there are a few different policies that look at whether or not the prosecutor, the types of situations where prosecutors move forward or dismiss. So those four kind of policies are trial sufficiency. So if the odds of a conviction are good, the prosecutor would not dismiss. They would move forward. For system efficiency here, the goal would be to kind of minimize the workload. Meanwhile, so this would be to just keep the case moving, or dismiss cases that you can't win, but ultimately to just run as efficient of a system as possible. Defendant rehabilitation looks more at new offenders being diverted and nonviolent offenders being diverted, so there's kind of this policy of diversion when possible. So some things that impact when prosecutors are making these decisions are the likelihood to just avoid uncertainty. Prosecutors don't like to take cases forward and spend money when they don't actually obtain the conviction, and how convictable this defendant is, and other characteristics like the suspect's race, ethnicity, religion, and the victim's characteristics. Prosecutors do want to make decisions that avoid appearance of them being biased, so that is something that impacts their decision. Hi, Johnny. Now, other factors that affect the prosecutor's charging decision, one is something called downstream organization. Downstream organization looks at how prosecutors predict success. So prosecutors, when they attempt to predict how they're going to win or how likely they're going to make a conviction, they attempt to look at the case as if how a judge or jury would look at it to try and figure out if they're going to win or not. This often relies on perceptual shorthand. So we talked about this a little bit when we talked about sentencing disparities earlier this semester. We talked about focal concerns theories and how judges tend to reduce things to kind of some focal concerns, and that those focal concerns often result in judges relying on perceptual shorthand or using stereotypes about the defendant's characteristics to make their decisions. So that perceptual shorthand occurs for prosecutors as well when they're making these decisions. They have high case volumes coming through constantly, and they frequently do, when they're trying to figure out how a judge or jury is going to move forward, they're basing it on stereotypes of what they think is likely. So that can be problematic. And they're just in that it might introduce some bias. So there are a couple of constraints on prosecutorial discretion, one being that prosecutors' refusal to file charges can be evaluated. Somebody can go to the prosecutor's supervisor or the judge. The Supreme Court does not look kindly on this. They've indicated that the prosecutor should have the decision here. Now, the Supreme Court has said prosecutors don't have completely unlimited discretion, but they have a ton of discretion. So some of the limits that the Supreme Court has laid out is that prosecutors' decision to charge should not be based on race, religion, or arbitrary classification. So this would kind of be some protected characteristics under the 14th Amendment Equal Protection Clause, most likely. Under the due process of law, prosecutors' decisions should not be vindictive. This is more narrow than it sounds. This is really only dealing with the prosecutor's decision in the pretrial phase to up the ante for a defendant who took steps to raise an issue on appeal during the pretrial phase. So prosecutors can't respond to that by upping the ante here. Prosecutors can negotiate charges, and under the American Bar Association, it notes specifically that prosecutors are not obligated to charge a criminal defendant with all of the charges that they could. Now, talk a little bit more about the information in the indictment. So in information, prosecutor's information details the charges that the defendant is facing. This is used in states, particularly in states that don't rely on grand juries or that only reserve a grand jury for certain types of cases. Whereas an indictment is the mechanism to charge defendants in the federal courts. It's required by the Fifth Amendment. And here, the grand jury looks at, is there sufficient evidence to charge this defendant? So grand juries usually have 23 people. They're closed proceedings, and the thought is that pushing the decision about whether to charge or not to a grand jury is a check on prosecutorial power. So the grouping these people together can check a prosecutor's power and make sure that they really do have enough information. The grand jury returns either a true bill, which means that they are going to indict, or a no bill, which means that they are not going to indict. If the grand jury returns a no bill, the case is usually over. No matter how a defendant got charged, whether it be through an information or a true bill, an initial appearance occurs after the defendant's been arrested and booked. All of the cases indicate that this should be done without unnecessary delay. Here, the judge will explain the charges and rights to the defendant. If we're dealing with a misdemeanor case, the defendant might enter their plea right then and there for a misdemeanor-only case. And the judge might even issue a sentence right then and there, such as putting the defendant on probation. For felony cases, that does not happen. A lot of times the cases where initial appearances occur, those judges are not authorized to take felony pleas. So they might talk about bail or other things at that point. So for bail, the judge decides whether to allow bail or not, how much the bail is going to be, and we don't have a right to have bail. Well, if we do have bail, it cannot be excessive under the 8th Amendment. So now we're kind of frequently dealing with felony cases. So during the arraignment, defendants are formally entering their plea in felony cases, because remember, most misdemeanors will plead out in the initial appearance. So we have guilty, not guilty. If they stand mute, the judge will enter a not guilty plea. They can plead no contest here, or they can enter the Alford plea. So those are the types of pleas. These should all be reviewed because we talked about these before. After the arraignment, usually pretrial motions will happen. We have a variety of motions, dismissing charges, all these different types of motions to get discovery, suppress evidence under the exclusionary rule, sever defendants. This is if we have co-defendants. The general rule is that we're going to try co-defendants together, but that might not be the best outcome for individual co-defendants. So the lawyers can move to separate them, determine competency for defendants who are mentally incapacitated, again, change venue. The judge's rulings on all these pretrial motions set the parameters for the case, and they can even determine the outcome. There is something called motion practice, and frequently defendants who lose their pretrial motions, their clients will plea out because they don't have a chance of winning at trial if certain evidence comes in or things like that. So, pleading out, plea bargaining. We know about more than 90% of cases plea out. In the 1960s, we saw plea bargaining really increase, but it's been around since just after the Civil War ended. This is to increase professionalization, minimize caseload. Now, talking a little bit about what plea bargaining is, all plea bargains involve a guilty plea. But not all guilty pleas are the result of a plea bargain. Sometimes defendants just plead guilty without a plea. After the plea bargain agreement is reached, there's an allocation where the defendant explains to the judge and admits to committing the crime. If we're dealing with that Alford plea, they explain why they're taking the plea. So types of plea bargaining. Charge reduction plea bargaining. Here the defendant is pleading guilty to a lesser charge. The charges are reduced. That's what the defendant is getting by the guilty plea. The prosecutor can recommend the sentence or stand mute here. Sentence agreements. Here the prosecutor and judge agree on what the outcome should be, and the judge accepts the sentence. The judge can accept the sentence or usually they will allow the withdrawal of the plea if they're going to reject. Sentence agreements limit judicial discretion. Ad hoc plea bargaining can result in some unusual confessions for the defendant, such as, they're not the standard if you'll have a lesser charge or this will be your sentence if you plead guilty. They can involve other things. So there are extraordinary conditions of probation, unauthorized forms of punishment, unauthorized benefits, unauthorized offense, and unauthorized forms of punishment. So there's a lot of different unusual things that might occur during ad hoc plea bargaining. Just unusual things. So the benefit of plea bargaining is that it's efficient, prosecutors get convictions, limits caseloads, victims get certainty of knowing that there's going to be a conviction for the harm they experience. Against our decisions, prosecutors overcharged to gain leverage. It's can be mercenary, and it does undermine the trial process. So because of some of these, there have been attempts to restrict or ban plea bargaining. Alaska has banned it. There are cutoff dates. So Brooklyn, you have 74 days. There's 74 days to plea after the indictment. Otherwise, you cannot. You have to take the case to trial. There are hybrid models. One is called the slow plea of guilt. Here, the defendant has to waive their right to a jury trial to have the possibility of plea bargaining. So that's the slow plea of guilt. Asking whether or not race or ethnicity matter. There's not a lot of research. There's not a lot of data to look at and figure out what's going on here. From what we can tell, decisions are frequently based on strength of evidence, prior criminal record, and seriousness of the offense. And those are the usual issues there. Lastly, for jury selection, this matters because it impacts who makes it to the jury panel. So if you have any questions, let me know. I look forward to hearing from you.